Welcome to the 5-Minute Legal Toolkit, a vlog in which I will go over a legal topic or tip in 5 minutes or less. The term evidence, when used in the context of a legal case, is anything that can be used to prove or establish a fact. During a trial, a fact is used to demonstrate whether something is true or not. Today's episode will review the 4 types of evidence that can be used by lawyers and pro se litigants in a court of law. And a pro se litigant is someone who represents him or herself without legal counsel. The law recognizes 4 types of evidence: real or physical evidence, testimonial evidence, demonstrative evidence, and documentary evidence. Let's go over each one. Real or physical evidence are material, tangible objects, items, or things that the judge and jury can examine for themselves. For example, fingerprints, audio recordings, blood samples, computer printouts, photographs, clothing, vehicles, weapons, and other physical items are examples of real evidence. Real evidence is introduced at trial through, most often, testimonial evidence, which we will discuss next. Why do you use testimonial evidence to introduce real evidence? Well, the court must be convinced that the real evidence is authentic, material, and relevant. Next, testimonial evidence. This type of evidence consists of any statement at trial made by a witness who is placed under oath and subject to direct examination by the party calling the witness, and then cross-examined by the opposing party. The third type is demonstrative evidence, which is evidence that offers an illustration or graphic of a presented fact and is generally used to clarify, explain, and present a visual perspective for the court. Demonstrative evidence can take the form of charts, diagrams, maps, photographs, video animation, graphs, slideshows, drawings, computer graphics, simulations, and other visual aids. The last type of evidence is documentary evidence. Documentary evidence is best described as items that are reviewed for its content and not its physical characteristics. Similar to real evidence, documentary evidence often is introduced at trial through testimonial evidence, again to inform the court whether that evidence is authentic, material, and relevant. Documentary evidence takes the form of emails, text messages, contracts, invoices, photographs, voice and video recordings, website pages, business records, public records, and written statements. Lawyers and pro se parties use one or combination of 4 types of evidence we just reviewed to establish facts at trial. Once the evidence is presented, it is the court's role, whether it be the judge in a non-jury trial or the jurors in a jury trial, to weigh each type of evidence and make a determination as to the weight that each piece of evidence will be assigned at trial. It is important, therefore, for parties in a court case to use every effort to locate and use the best and most relevant evidence that proves his or her case or defense.